the Anti-Death Penalty Asia Network, an organization advocating for the abolition of the death penalty across the Asia-Pacific region, has been served with a correction order by the Singapore government under the Protection from Online Falsehoods and Manipulation Act. The order, initiated by Minister for Home Affairs and Law K. Shanmugam, was directed to the POFMA office in response to alleged false claims made by ADPAN in social media posts on 3 October 2024. These posts pertain to Singapore's legal processes for death row prisoners and the treatment of activists opposing the death penalty. The posts, shared across Facebook, Instagram and LinkedIn, were released just before the scheduled execution of Mohammed Azwan Bahari, a drug trafficking convict, who had been sentenced to death for possessing over 6.5 grams of pure heroin. ADPAN's posts claimed that Azwan had been subjected to an unjust burden of proof and described the sentencing system in Singapore as arbitrary. Additionally, the posts accused the Ministry of Home Affairs of ignoring legal proceedings in its push to carry out executions and alleged that authorities were harassing Singapore-based anti-death penalty activists. In its statement on 9 October, the MHA stated that the correction order addressed two major falsehoods. First, the assertion that executions in Singapore are carried out without due legal process, and second, the claim that the government targets, silences, and harasses anti-death penalty groups, such as the Transformative Justice Collective. The ministry emphasized that Singapore takes a strict stance against the deliberate spread of false information, especially when it could undermine public confidence in the nation's institutions. According to records, to date, Mr. Shanmugam has issued 18 correction directions under POFMA to various individuals, media outlets, and civil society groups on behalf of the MHA and the Ministry of Law. Addressing the case of Mohammed Azwan Bahari, MHA clarified that Azwan had been afforded legal due process throughout his trial and subsequent appeals. An execution will only be scheduled when a prisoner has exhausted all rights of appeal and the clemency process in relation to his or her conviction and sentence. This was so in Azwan's case, asserted MHA. MHA highlighted Azwan's previous conviction in 2009 for drug trafficking, which led to a 5-year prison sentence. He was released in October 2014, but was rearrested in October 2015 for drug trafficking. MHA claimed during his trial, although Azwan did not contest ownership of the drugs found in his possession, he denied intending to traffic all of them, claiming half was for personal use. However, MHA pointed out that under Section 17 of the Misuse of Drugs Act, possession of more than a specified quantity of drugs is presumed to be for trafficking unless the accused can prove otherwise. Even where the prosecution relies on this presumption, it still bears the legal burden of proving the material elements of the charge beyond a reasonable doubt, that is, the fact of possession and knowledge. The use of such presumptions is only an evidential tool to prove certain elements of an offense, after a predicate fact has been proven by the prosecution. Further, this presumption can be rebutted if the accused person is able to show, on a balance of probabilities, that he or she was not trafficking in drugs. Azwan, who was convicted and sentenced on February 11, 2019, had his appeal dismissed by the Court of Appeal on October 24, 2019. Further, 2 clemency bids were unsuccessful. On 12 April 2024, he was notified that his execution was scheduled for 19 April. MHA detailed that by the time of his execution notice, Azwan was involved in only one legal proceeding, an application challenging the constitutionality of the Legal Assistance Scheme for Capital Offences, a scheme that provides free legal counsel to those facing capital charges. The ministry emphasized that this application did not request a stay of execution. It was only on 16 April, 3 days before his execution, that Azwan submitted a motion for a stay of execution, prompting the Court of Appeal to issue a temporary stay on 7 April while considering the LOSCO application. On 20 May 2024, the High Court struck down the LOSCO application, with the Court of Appeal dismissing a subsequent appeal on 9 September. On 19 September, Azwan, along with 30 other death row prisoners, filed another civil application challenging specific provisions of the Capital Cases Act 2022. However, MHA pointed out that this civil matter did not impact Azwan's conviction or sentence, nor did it request a stay of execution. Azwan received a new execution notice on 30 September, with the date set for 4 October. Despite filing another last-minute application on 1 October for a stay of execution, the Court of Appeal dismissed it on 3 October. The court ruled that Azwan's intended review application had no prospect of success whatsoever, and found no grounds to challenge the validity of his conviction or sentence. In response to ADPAN's claims that authorities targeted anti-death penalty activists, including the Transformative Justice Collective, MHA categorically denied these allegations. The ministry stated that any action taken against activists was in response to the spreading of false information and was conducted in the public interest to preserve the integrity of the criminal justice system. The Transformative Justice Collective has been issued several POFMA correction orders for its posts on the death penalty. MHA argued that these posts cast serious aspersions on Singapore's legal system, posing a risk of eroding public trust in governmental institutions. The ministry noted that these correction orders did not require the removal or alteration of the original posts, stating, "Readers can still read the falsehoods and consider the government's clarifications alongside it." ADPAN has since complied with the correction order by adding a correction notice to the original posts on its Facebook, Instagram, and LinkedIn accounts. In its latest response, ADPAN highlighted on its Facebook page that it received the POFMA correction order on 9 October at 11 p.m, coinciding with the eve of the World Day Against the Death Penalty. The Executive Committee of ADPAN stated that it has decided to engage with the order. Let it be known that ADPAN stands by its statements, expressions, and opinions, which are protected by international human rights law and standards. We stand in solidarity with human rights defenders and groups on the ground. ADPAN also reserve the right to issue further statements on the matter.